Judgment in the appeal and Lang against Queen.
The appellant Andrew Lang was convicted in Bermuda in 2007 on drugs charges and an assault charge. He received concurrent sentences of 17 years imprisonment on the drugs charges and 1 year on the assault charge. He appealed against his conviction, arguing that the trial judge's directions to the jury in relation to the evidence against him of his co-accused, Miss Herrera, were inadequate. She had pleaded guilty to drugs charges and obtained a reduction in her sentence on appeal for testifying against Mr. Lang. Mr. Lang also appealed against his sentence. In March 2009, the Court of Appeal for Bermuda dismissed the appeal against conviction and refused the appeal for the application for leave to appeal against sentence. The court did not give any reasons in writing for its decision. In July 2012, Mr. Lang applied for permission to appeal to the Judicial Committee against the court's decision on the ground that he had been deprived of the protection of the law and of a fair hearing because of the failure of the court to give reasons for its decision. In March 2013, the board allowed the permission application to be made out of time and directed that there should be an oral hearing on the procedural ground that the court had failed to give reasons for its decision. At the oral hearing on the 23rd of April, the board allowed counsel to argue that permission to appeal should also be given on the substantive ground that the trial judge's directions in relation to Ms. Herrera's evidence were inadequate. His point was that her evidence was inherently dangerous and that the trial judge had failed to give the necessary warning to the jury. The board will humbly advise Her Majesty that the application for permission to appeal on both grounds should be refused. There is no substance in the criticism of the trial judge's directions. She dealt with the two grounds on which Ms. Herrera's evidence had to be treated with caution. These were that she had a grudge against Mr. Lang and a motive for giving evidence against him. She warned the jury that they must treat her evidence with the utmost caution. She also told them that as there was a special need for caution, where her evidence was disputed by Mr. Lang, they would be wise to look for some supporting material. The board has concluded that it is not arguable that her careful directions were inadequate or that the conviction is unsafe. Had there been merit in the appeal on the substantive ground, the board would have been inclined to give permission on the procedural ground so that a remedy for the apparent failure to give sufficient reasons could be given. But it cannot be the case that if a conviction is otherwise sound, as it is in this case, it would have to be quashed simply because of a failure by the Court of Appeal to give its reasons for dismissing a conviction appeal. 3 points can be made which may help to put the criticism of the appeal court into its proper context. First, it appears from a note made at the time that brief oral reasons were given for the decision that there was no merit in the appeal, which were directed to the question whether the trial judge's directions were adequate. Second, the board was told that the practice in Bermuda is that if there is no new or novel point of law, the appeal court will not give written reasons unless it is asked to do so, and then generally only a transcript of its oral reasons. No such request was made in this case. Third, Article 6.1 of the European Convention on Human Rights has been interpreted as obliging courts to give reasons for their decision, but it does not require a detailed answer to be given to every argument. Whether a court has failed to fulfill the obligation can only be determined in the light of the circumstances of each case. The giving of reasons by the board is enough to make good any inadequacy in the reasons that the appeal court gave for its decision in this case. However, the situation in this case cannot be regarded as entirely satisfactory. Members of the board are well aware from their own experience of the pressures endemic to a criminal appeal court. But the interests of justice must come first. An appellant has a constitutional right to be given the reasons for the court's decision if his appeal is dismissed. The more serious the offence and the more severe the sentence, the more important it is that this right should be given effect. This should be done by giving written reasons for the decision, or where reasons are given orally, for them to be recorded so that they can be transcribed as soon as possible. Only then can one be certain that the constitutional right has been satisfied. It will always be a matter at the court's discretion how much need to be said and whether it should deal with every argument. The guiding principle in this matter is one of fairness.